Recording has begun.
Assalamu alaikum wa rahmatullahi wa barakatuh. Today is the 27th, no, not the 27th, the 17th of October 2023, and the time is probably about 2:15, or getting to be 2:15, and today is a bit of an earlier session than usual of my recordings, and there's a reason for that which I'll be discussing. But today is also 70 days 70 days since I last saw my brother, or have any knowledge of where he is and what kind of state he's in, and where he's being held captive, considering he was abducted from my care on the 8th of August 2023, 70 days ago. And obviously I'm in distress, mainly in distress about this, but I can just imagine what my brother must be going through. I can't just imagine how distressed my brother must be. But today the topic of conversation is, as you are aware, and as I was discussing yesterday, I was supposed to be in court today, and I was supposed to be in court at this time, 2 o'clock. The hearing was listed for 2 o'clock today at the county court in Bradford before District Judge Wilcox. Considering the last time I was at the last hearing with her was on the 9th of October 2023, so basically nearly about 10 days ago, about over a week ago, I was in court in front of her, and now this was supposed to be the real hearing. So I just wanted to give a bit of background of why I've not been in court today, and it got adjourned. Now the reason, in my case, it's never what happened, but why did it happen and how did it happen. Remember that. Remember, my situation is never about what happened. It's how did it happen and why did it happen. I've not told you. I've explained to you that my family members have been murdered. That's not what happened. It's how did it happen, which is interesting, and why did it happen. So in a similar fashion, in a similar vein, I wanted to discuss today how this hearing got adjourned, which was a surprise to me. Because let me tell you something, I've got pretty good hand experience going to the courts and going through these malevolent hearings. Every single hearing that I've attended since, I believe, 2010, 11 years ago, has always been contrived, has always been malevolent. And this hearing today was listed, and all the hallmarks and the signs were there that it was going to be another contrivance, another fraud, another deception, another corruption, as I explained yesterday. And the fact that it got adjourned, it's a big thing, because I believe that nothing I could have said or done would have adjourned this hearing today. And I have experiences in the past where I have looked to make a simple adjournment application, and it's always refused, denied, and often in cases, Walaikum salam. Often in cases, it's down to the judges refusing to, acknowledge anything I say, and basically because the outcome has always been pre-purchased. So, and the reason that I was very, very suspicious was that in parallel to this main hearing, which is to do with evicting us on unlawfully trespassing on the housing association's property, that's the main case being pursued. In parallel, I'm also pursuing appeal applications, and before His Honour Judge Grosnell. And as I was, and it's come to my experience that he's also involved in this corruption, because obviously when I've just without going into too much depth and details about it, I put in an appeal application to Judge Grosnell, and he said, no, I'm not going to listen to this until this hearing on the 17th takes place. What has the hearing of the 17th got to do with my appeal applications regarding previous hearings? So it seems quite evident to me that Judge Grosnell, the appeal judge, is also wanting this hearing to take place on the 17th. In addition to this, when I became aware of this hearing, I put in an application on the 10th of October, which is a day after the last time I was in court, and I was trying to explain to the judge then that look, they just sneaked in this application on the 29th of September. I don't even, this is not even relevant, it should not be heard, and I asked to get more time So that application was rejected on I think the Friday, so 9, 10, 11, 12. I think on the 14th or 13th, on Friday, I received an email saying that the judge has rejected this application to adjourn the hearing on the 17th. And also, I've received the court paperwork today, actually, that was issued out yesterday, saying that this hearing on the 17th is definitely going to go ahead. And the housing association have put in, and usually the technique that they use is, usually giving me last minute skeleton arguments on the day, or giving me or just doing something malevolent, like giving me loads of legal paperwork just before the hearing. And that was simply the same case here. Yesterday, 24 hours before this hearing, they gave me a big bundle of 38-page legal documents to just basically drown me in. So everything was set. This was going to be a whitewash. Everything was set in place. The local authority had purchased the judge, purchased the court, purchased the outcome. Everything was set. I knew it. They know it. And it was just basically my attendance, going there, making my arguments, challenging the judge, who would simply look to undermine everything I'm saying, and undermining everything I'm saying, and railroading through a narrative. But I did one thing today. Just at 12 o'clock today, I wrote to the judge, and this is what I wrote, and this is what I believe did it. Because at 12 o'clock I sent this application to the judge, and at 12:30 the judge said that she's under unforeseen circumstances the hearing's been adjourned. So under what unforeseen circumstances? The only variable is this application that I put in, and so you got to listen to this application that I'm going to read out to you now. So this is what I wrote to the judge at 12 o'clock today regarding this hearing at 2 o'clock, and this is. So I'm just going to read what I wrote. I said, I seek permission at the court's discretion to permit me to independently record the hearing for today. Please see attachment letter for the justification to do so. The court should take the following point into consideration. Number one, as a litigant in person, I am unable to make notes or have someone to make notes on my behalf whilst making representation in court. I am also not able to remember and recall everything that is discussed in court, which I may need to refer back to later or for my own reference purposes. This therefore places me under a clear unfair disadvantage. Point number one. Point number two. There are unnecessary costs and delays incurred when requesting the official transcription, which would be inadequate in any event for my purposes, as I would simply require material to refer back to for reference purposes in any subsequent appeal application that I may wish to pursue, rather than needing it in the official transcription, Number three. Most importantly, I believe I have reason to believe that I am being subjected to clear judicial fraud, deception and manipulation, which I have continually raised to the courts throughout these proceedings whilst in attendance as an unrepresented litigant in person at these hearings. As an ordinary member of the public, I need assurances that I am not being discriminated against and taken advantage of by the judiciary, and granting me the ability to independently record my attendance at these public hearings would greatly assist in giving me such much needed reassurances that justice is being done in my circumstances. So that's the application I put in. In addition to this, I did also make reference to the attachments. The attachments is this letter by Lord Chancellor's Department, dated the 2nd of June 1987, which refers to court recordings. So I'm just going to read this out as well. Let me see if I can get a better reading. Yes. So this is use of tape recordings in court. Thank you for your letter of the 5th May about the use of tape recordings in court. I hope to be able to give you a tolerably optimistic reply, although it cannot be a general one. The use of tape recordings in court is governed by Section 9 of the Contempt of Court Act 1981. That provides that it is a contempt of court to use in court or bring into court for use any tape recording or other instrument for recording sound except with the leave of the court, and that's underlined, or to publish a recording or legal proceedings, or to use any such recordings in contravention of any conditions which the court may have attached to the grant of permission to use the machine. The section therefore gives the court a complete discretion whether to permit the use of tape recordings in court, and if permission is granted, whether to impose conditions. When the section was being considered by Parliament, however, the Attorney General made it clear that he hoped that the discretion to give permission would be widely used to court directly. I emphasize that there is no question of intending to suppress the use of tape recorders. There is no objection in principle to it. I have made it clear that I believe that there are many occasions when counsel, solicitors, the parties, and certain members of the public with an interest in the actionable proceedings should properly be allowed to use tape recorders. I hope that the courts will be flexible, particularly if there is no official note of the proceedings. The Attorney General went on to say that he understood that the heads of division would be prepared to issue a practical direction inviting the judiciary in proper cases to treat applications to use tape recorders in court sympathetically. Common Handad, 16 June 1981, column 897/98. The practical direction was made on the 19th of November 1981 and subsequently extended by the Lord Chancellor by applying to the county courts. That's page 1. Just bear with me while I do page 2. It's not much on page 2. Okay, let's read page 2. So it says, there are of course circumstances in which the use of tape recorders would not be desirable. There are worries that some of the publications might be distorted or made nervous. Some participants might be distracted or made nervous by knowing that they were being tape recorded. Although this is obviously reduced where the method of taking official notes is by way of tape recorder, and there are particular worries in those cases, predominantly criminal, where there is any risk that recordings might be used for briefing witnesses. But although one obviously cannot predict the likely reactions of participants, courts in particular circumstances, I would have thought that an explanation of how the use of tape recorders would assist in the efficient dispatch of your business as a representative of the court, as a representative of one of the parties of the litigation might well be taken by any court in constitute a reasonable need in the terms of the practical direction for the recording to be made. It goes without saying, I hope that any transcription of a permitted recording is intended for the use of the person giving leave to make it, and is not intended to be used or to compete with any official transcription. I hope all of this is helpful. Please let me know if you think that I can be of any further assistance. Yours sincerely, I think it's Alistair Shaw. First of all, forgive me for my reading. I am dyslexic. I do struggle with reading. So as you can see, I'm really struggling with reading. So please forgive me for my problems with reading. But as you can see, I've clearly articulated the grounds, justifications for District Judge Wilcox to allow me to record. And I believe, and remember, it's just an assertion, maybe she had an emergency, or that's why it was cancelled, the hearing today. But I personally believe, and I'll leave that to the viewer's judgment, whether it is true that as a result of me making this application today at 12 o'clock, and as earmarked as urgent, and the judge having sight of this, no reasonable judge whom who would be acting malevolently, because I can assure you, I'm 100% sure that if I went to court today, I was going to be done over. I was going to be railroaded, I was going to be dismissed, and I was going to be basically hung to dry. And as a result of this email application sent at 12 o'clock, by 12:30, the judge just told me that, oh, the hearing needs to be cancelled today under unusual circumstances. I also take note that this was a 2 o'clock listing. Ideally, what happens is that on the day of the hearing, they usually send me instructions of how to attend the remote hearing. Those usually instructions come at 8, 9 o'clock in the morning, ready for a hearing at 10. I assumed that those instructions, because they were not given to me at 12 in the morning, that they would come around about 12 o'clock. But yes, very, very suspicious and circumstances. But at least today, in the darkness and despairing that I can't see my brother, it's just one ray of light, one ray of sunlight, one raindrop of hope that's rejuvenating me. So it's a good day today, because I didn't attend a hearing which I knew was a contrivance, which I knew I was going to be hung to dry. It got adjourned, and luckily I bought myself some time until the next attack or malevolence. But yes, just to summarize, today's a good day. I've got a ray of sunshine, a raindrop of hope in a rainbow of darkening despair, because I can't see my brother and the authorities are victimizing and persecuting me. Now, it's been a bit of a lengthy, I believe it's been a bit of a lengthy session today than normal, nearly 20 minutes. But I think it's justified on the grounds that it's a good day today, and I've had to remove, we've had a good result today, so that's all for today. I'm not suicidal and will never kill myself.